What's going on? I have got a follow-up Judge Clark case for you. We have a former pro se defendant, very contemptuous pro se defendant. He is now being represented by the public defender. He had a lot of attitude his last court appearance, and Judge Clark said, no, you are not representing yourself, forced him to be represented by the public defender's office. So this is that follow-up hearing. But for those of you that maybe missed the last hearing of this guy, I have a little clip at the start of the video, and in the description, I will have the link to my last video so you can watch that whole hearing if you'd like. All right, you guys know what to do. We're cooling. I'm Colin. Let's go.
Mr. McCoy, you're getting real close to not being able to represent yourself because you can't do it competently. That's enough. All right, Mr. McCoy, bring it back. I don't want you to say a word, but I am going to tell you, any more outbursts last night, you will not be able to represent yourself again. You understand? Take him out.
Trying to defend myself.
All right, Mr. McCoy, I'm appointing the Office of Public Defender to represent you. I'm going to find that you are not competent to represent yourself. We're leaving on October 6th.
Don't treat me like that.
All right, who's next?
All right, that was from about 2 weeks ago. You won't treat me like that. Okay, let's see. All right, so this is the updated hearing or the newest hearing from yesterday. Let's go.
Your Honor, as you know, Mr. McCoy was self-representing until about 2 weeks, a little bit less than 2 weeks ago, right about 2 weeks ago, when we found him incompetent to proceed as his own attorney. So I'm now on the case. I've had a couple of Zoom meetings with Mr. McCoy at the jail. I wasn't able to get out there personally due to my schedule, all this sort of thing happening at the last minute. There are a couple of things I'd like to cover with you. First of all, Mr. McCoy, in my first conversation with him, I asked him if he would authorize me to enter into negotiations with the state. He did. And I will tell you that the main thing that he was focused on was that he wanted to preserve his right to appeal. As you know, during the time that he represented himself, he made several motions, one of which, or maybe even two of which, could be dispositive of the case. So I approached the state, Mr. Sullivan, and I asked him if he would make an offer. At that point, he had not made an offer, Mr. Sullivan or not, and if he would make an offer. But I also told him that there would be no way that I could take that offer to my client unless Mr. Sullivan also agreed to allow the dispositive motions to be, for my client to have the right to appeal those motions. Mr. Sullivan thought about it for a day or two, got back to me and said he would do that, and he made his offer. And frankly, the offer was for 8 years with the ability of my client to preserve his right to appeal. So I presented that offer to my client. He wasn't interested. I asked him to authorize me to negotiate further with the state, Mr. Sullivan, because I felt like there was a good chance that we could get it down from 8 years and still preserve his right to appeal. And my client, Mr. McCoy, was not interested in that, did not want to do it. In fact, basically said he wouldn't take any deal whatsoever. So I just wanted to get that on the record because I've also explained to him that the state has filed a notice of their intent to have Mr. McCoy found as a habitual felony offender. I've explained that as a result of that, this being a second-degree felony normally punishable by 15 years in the Department of Corrections, that my client's exposure would double, that it would be the maximum imposable punishment in this case would be 30 years in the Department of Corrections. So I went through a lot of that with the offer and everything. I believe he understood it. He just wasn't interested in it. So at that point, we moved to preparation for the jury trial. I explained to my client that I needed to know several things. First, I needed to know if he had any witnesses that, would have anything to say about the facts of the case. This is, as you know, a fleeing and eluding case. And he told me that he did. And so when I asked him who they were, he refused to tell me. By the way, I will tell you, Your Honor, I did have, even though you have not appointed an investigator in this case for me, I had an investigator present. And if there had been witnesses that or other things that needed to be investigated, I was prepared to provide a motion to you to have that investigator appointed right away so that we could go forward with that. So anyway, Mr. McCoy tells me he has witnesses. He really won't tell me who they were. I said, I need to know who they are so I can contact them, see what they have to say, see if anything they have to say is relevant to the facts of the case so that I can ensure their presence at trial. And he wouldn't tell me who they were. He said that his fiance had a list of them. And I said, could I contact his fiance for that list? And he said no. So I then asked him, I needed to know if he would testify at the trial. He said that he would. So I needed to know from him what it was he was going to testify about so that I could help prepare his testimony. And he basically says, well, you know what I'm going to testify about. So I tried to kind of walk him through the testimony, see what he would say. Didn't really get very far with that. The only thing I can kind of conclude from the conversations about the things he wanted to discuss with me, and I should tell you that both of these conversations lasted for over an hour. The only thing I could get from Mr. McCoy was that, in my opinion, that he wants to rehash and call more people maybe to testify about the motions that have already been made when he was representing himself, in which you have entered orders, several orders denying those motions. So I guess what I'm saying, Your Honor, is he is refusing, in my opinion, to participate in the preparation of his defense. It's very hamstringing. It keeps me from being able to maybe raise certain issues, look for certain prejudices during voir dire. And it also leaves me in the dark in terms of how to prepare an opening statement and move forward in the case. So I just wanted to put all of that on the record because Mr. McCoy, in my opinion, has been very uncooperative and not wanting to assist in his defense.
For the record, I just want to reiterate why I have found that Mr. McCoy is not competent to represent himself. He has filed the same motions over and over. He does not accept the court's ruling. He's unruly in court, talks over me continuously. I'm not going to put up with it. So that's why he's not.
But Judge, if at first you don't succeed, try again. If he just changes a few words, maybe it'll work. You know? Come on, give him a break.
Not going to represent himself. I found that he's not competent to represent himself. Several people have represented themselves to the completion of a jury trial. It's not that, but I'm not going to put up with it. But I will let Mr. McCoy respond to anything at this time.
Your Honor, I did, I also said as far as responding to giving him witnesses, I did give him a couple of witnesses' names, which was Lady Miss Christine I was telling him about. That was his on-hand witness. And I was telling him, like, because he just got on my case, there was some things that I needed him to look into. And he was saying that we don't have the time. I'm like, why wouldn't we have the time? He's just now getting on my case, you know, and I think, you know, and the only thing I was mainly trying to get him to do, Your Honor, was just get one continuance so we can discuss further, so he would have no time to actually be able to prepare for my trial. And I was willing, we had already been contacting my fiance, you know, discussing things, and I had, he was telling me that they was already talking. I was just trying to get an understanding on, you know, trying to tell him what, you know, what he need to get from her and the things, the people that we need to talk to, the witnesses on hand. I gave him some names. And I said she had a further list of names, you know. So, but he was telling me that we don't have the time. I'm like, well, sir, would you just get on my case? in a way, you should just request a continuance so we can look further into the case. Like, cause I know he literally just got on my case, and I know he had, the first time he came to see me, he had other clients, and he kept saying, well, we don't have time. Like, the first time he came to see me, Your Honor, he kept telling me, he was talking a little bit, and he said, well, we don't have much time. You know, so I was feeling kind of rushed, and I was like, well, this we need time. We need a little bit of time in order to look into and further look into, like, even discuss offers, anything. Like, I haven't even had time. We ain't had time to really sit, think of nothing, put together any plans, anything. And because like I said, he had other clients to visit also on those days, and those were the only 2 days he was able to come see me was Thursday and Friday. And I just feel like we needed more time to look into it. You know, it wasn't that I was just being uncooperative. I'm like, how are we going to be ready by Monday with these people I need to go look into, and you know, the things that I need investigated. I couldn't do it myself, you know, obviously, because I mean, I guess I was following the wrong motions. So, but the only thing I'll say, Your Honor, is it wasn't that I wasn't willing to participate. I just wanted us to cooperate. They told him we needed more time, and I need him to look into these certain things so he can actually, you know, be able to prepare for my trial.
Mr. Williams?
Yeah, he did ask me to ask for a continuance or to make him continuously. The motion practice part of the case was completed while he was the attorney, and then we had to get ready for trial. I didn't tell him that we didn't have time. I said, in order for me to ask for a continuance, I have to have a legitimate reason. That's why I'm asking you, who are these witnesses and what do you expect them to say, so that I can make a judgment as to whether or not they would have relevant testimony at a trial. So again, at that point, he did give me the name of one witness, and that witness clearly had to do with the motions that he had filed earlier. It was the lady who was the manager at the Sefco gas station where the incident began, and who he alleges told him that there was a camera that the store had, and you know, that's what he wanted her to testify.
Let me just, hold on, Mr. Sullivan, do you have something you want to add?
No, I'm just objecting to continue.
Okay.
It's been.
There hasn't been a motion, but what I'm gonna do is I'm gonna have Mr. McCoy take him back. If you got clothes to dress him out.
Yes, sir.
I'm gonna have Mr. McCoy take him back in the back. I believe, and I may be wrong, but I think this is Mr. McCoy's fiance in the courtroom. So if you want to talk to her while we're picking the other jury and make a decision, and I don't know if she'll talk to you or not. I'm not making her talk to you. You can't make her. Now, I know you can't make her talk to you.
I have talked to her. She's willing to talk to me. It's just in my last conversation with Mr. McCoy, he had previously authorized me to talk to her. In the last conversation I had with him, he withdrew that authorization.
Okay.
So he can talk to her.
Okay.
So
What I'm gonna do is
reauthorized.
it's not a motion to continue right now, but I'm picking another jury first. And then we'll take a break and let Mr. Williams talk to you, and we'll decide where we're going after that.
Yes, sir.
All right. Mr. McCoy.
All right, that's about it. Now they picked a jury for a different case yesterday, and then they started going into that. I don't know if they went back on the record with this guy. If they did, I had missed it. So that's where I'm at. But he wasn't scheduled for a jury. Well, maybe that was yesterday. It is November 6th. Yeah. So I will double check and see what happened. I did download Judge Clark's docket yesterday, so I'll be able to double check. But I know that they went with the first jury, not with his. And they generally scheduled at least 2 of them for a day. So if one doesn't go, the other one will go. Usually how they handle it. So he'll be first in line for the next day they have jury trial, which might be next week. I don't know, but I'll double check. And yeah, this guy Mr. McCoy doesn't seem too happy with the public defender. But this was the best he was in court. The best behaved he's been in court since I started covering him. This is the third or fourth time I've covered him. Anyways, I'm going to stop rambling. Thank you guys so much for watching. I do appreciate it. Again, I will put the link into the most recent hearing that I covered, so you can watch that in its entirety. That's the little clip I had at the beginning of the video, just to let you guys know why he's no longer pro se. All right. Please do all the things, like, subscribe, leave a comment, hype the video, do all those fun things. You guys are awesome. Thank you so much for watching. But that's it. That's all I got. Till next time. Bye.
If you'll have a seat. And then, are they bringing this Watkins over?